Chair recognizes Mr. Spiller to explain the bill.
Thank you, Mr. Speaker. Members, this is the bill relating to agreements between sheriffs and the United States Immigration and Customs Enforcement to enforce federal immigration law. I have filed a floor amendment, and at this time I'd like to lay out that floor amendment.
The following amendment, the clerk will read the amendment.
Amendment by Spiller.
The chair recognizes Mr. Spiller to explain the amendment.
Thank you, Mr. Speaker. Members, I lay out this floor amendment to Senate Bill 8, which addresses immigration enforcement cooperation between Texas sheriffs and federal authorities. This substitute builds on the committee's work but improves clarity, consistency, and enforceability. Instead of just piecemeal changes through a series of amendments, we thought it best to present a clean and comprehensive framework that reflects feedback from local law enforcement, legal counsel, other stakeholders, and state budget officers. Let me explain what this floor substitute does. First of all, it applies statewide. Under the committee version, only sheriffs in counties with 100,000 or more population would have been required to pursue federal immigration enforcement agreements. This substitute extends that requirement to all counties in the state of Texas who operate or contract for the operation of a jail. So, and the reason for that is because immigration concerns don't just stop at county lines, and neither should our enforcement efforts. Secondly, standardization of the type of agreement. The substitute directly directs sheriffs to pursue a warrant service model agreement with ICE. Now, let me back up and explain. Under the Section 287G program under the Immigration and Nationality Act, there are three different models within which counties and sheriffs can contract with ICE. One of those is the task force model. That's the most comprehensive. The next one is the jail enforcement model. And lastly is the warrant service model. What we've decided to focus on here is that counties and currently can contract with ICE on any one or more of those three. But what we've tried to focus on here is saying, look, let's just at least require them, counties, to participate under the warrant service model form. And so that's what this bill does. There were some concerns about the way it was drafted, and so those are done just at the jail level, and specifically what that does, and that's where those risks are most severe. But it provides for warrants of arrest for immigration violations and warrants of removal. So unlike the other task force model where people go out and they're detaining
Mr.
people.
Romero, for what purpose?
Does the gentleman yield for questions?
Mr. Spiller, would you yield for questions? He will.
Let me finish my
Not
layout
at
here, and
this
I'll try
time,
to be
please.
quick about it. I apologize. But instead of doing that, this is just done in the jail for people that are arrested or that are already there on other charges. And so if a sheriff enters into a broader or more comprehensive agreement, they get credit for that. That satisfies the requirement. Number three, this provides meaningful state support. So it provides a tiered grant program based on population. So the rural counties, smaller rural counties aren't excluded. There's funding there for them. And under the other bill or the other version, counties over 1 million people did not receive any compensation. This provides for compensation to all participating counties. And the funding ranges are from $5,000 to $40,000. It also, and probably very importantly, provides for an annual reimbursement program. So in the event there are any costs associated with holding ICE detainees, local taxpayers don't get stuck with footing the bill for that. And so there's a reimbursement program built into this. It improves oversight and enforcement. The comptroller has biannual reports to state leadership, so we have transparency on who's cooperating and how state funds are being used. And also the Attorney General's office is authorized to enforce compliance and recover legal costs if a sheriff refuses to follow the law. Why is this good policy? Members, this isn't about politics. This is about public safety concerns and law enforcement consistency across Texas. Every sheriff should be equipped and supported to cooperate with federal immigration authorities. What we're saying by this legislation is that if you operate a jail in Texas, you should have a standing agreement in place to work with our federal partners and to serve and execute these warrants if they in fact exist. This policy protects our communities, ensures that dangerous individuals aren't prematurely released, and supports the rule of law.
Mr. Speaker.
Let me also say that I appreciate, we've worked very hard to bring this version to you, and I appreciate, we've had some Representative Romero is waiting patiently for me to finish, so I'm going to say this while I can. I appreciate working with him, Representative Canales, and others. We've had some very frank discussions. We could say that he's beat me up a little bit on this. That's a fair statement, but he's been very persistent, and we've tried to incorporate his concerns, Representative Canales' concerns, into this draft. And I've worked also, I'd be remiss if I also didn't point out Representative Louderback, a former sheriff who has executed and operated under these existing agreements and knows them like the back of his hand. I've worked very closely with him. I appreciate his efforts. I don't know where I'd be on this bill without his work. And I think also he will speak to this and answer any questions as well. But I do want to say thank you to those folks for us to have the best bill that we can for you and what I think is the best bill and the best policy for the state of Texas. And with that, I would yield to questions.
Hear you, Mr. Romero.